and today we are going to present the case of Donahue and Stevenson. The case of Donahue and Stevenson has established the modern law of negligence. In order to be successful in a negligent claim, the claimant must prove: first, defendant owed a duty of care; second, defendant breached of that duty; third, breach of the duty caused damage; and fourth, damage was not too remote.
Hi, I'm Wong Jia Huey. I will be talking about pre-Donahue, which is the case of Winterbottom and Wright. Before Donahue and Stevenson, the concept of duty of care did not exist in any particularly notable form within the English law. This means that unless a plaintiff had a contract with a defendant, they had no means of bringing a case in negligence. This led to a considerable number of injustice when individuals was injured by clear instance of negligence. An example of this phenomenon can be seen in Winterbottom and Wright. In this case, the defendant was contracted by the UK Postmaster General to maintain a horse-drawn mail coach in a safe state. Winterbottom, who was the plaintiff, was also contracted by the Postmaster General to drive the coach between destinations, but was injured when the coach collapsed due to disrepair. The court was asked to consider if the driver had any claims against the defendant. Although it was clear that Wright had acted negligently, the courts held that Winterbottom could not sue Wright because a contract did not exist between the two. In essence, the contract concept of privity prevented legal action.
In the case of Donahue and Stevenson, Mr. Donahue went to a cafe with a friend. The friend bought her a bottle of ginger beer and an ice cream. The ginger beer came in an opaque bottle so that the contents could not be seen. Mr. Donahue poured half of the contents of the bottle over her ice cream and also drank some from the bottle. After eating part of the ice cream, she then poured the remaining contents of the bottle over the ice cream, and a decomposed nail emerged from the bottle. Mrs. Donahue suffered personal injury as a result. She commenced a claim against the manufacturer of the ginger beer. In this case, Lord Atkins stated that the principle was that you must take reasonable care to avoid acts or omission which you can reasonably foresee will be likely to injure your neighbor. This is known as neighbor principle. By neighbor, Lord Atkins did not mean that the person who lives next door to you, but the person who was so closely and directly affected by my act that I ought to have them in contemplation as being so affected when I'm directing my mind to the acts or omission which are called in question. The test of foreseeability is objective. The court asks not what the defendant actually foresaw, but what a reasonable person would have been expected to foresee.
Hi, I'm Amir. The decision of Donahue and Stevenson and Lord Atkins' neighbor principle eventually became the baseline for deciding cases of negligence. This can be seen in the case of Home Office and Dorset Yacht Company. This was an English case regarding 10 Borstal trainees who were employed by the Home Office. While the officers in charge of these trainees had retired to bed, some of the trainees snuck out. The trainees then proceeded to steal a yacht and take it for a joyride. Eventually there was an accident whereby they collided with another yacht, causing massive damage to both vessels. The owner of the yacht sued the Home Office for damages under the tort of negligence. Lord Reed, in delivering his judgment, referred to Lord Atkins' neighbor principle. However, he did concede that the principle should not be treated as statutory definition and would require qualification in new circumstances. However, Lord Reed did not feel there was a valid justification for its exclusion in this case, and so he readily applied the principle as it were, with a particular emphasis on the foreseeability aspect. He said the following: The taking by the trainees of a nearby yacht and the causing of damage to the other yacht, which belonged to the respondents, ought to have been foreseen by the Boston employees as likely to occur if they failed to exercise proper control or supervision. The decision of Donohue and Stevenson was also implemented in other Commonwealth countries. For example, the case of Grant and Australian Knitting Mills, which was an Australian Supreme Court case. The plaintiff had purchased a pair of woolen undergarments from a retailer. There was no indication on the packaging of the garments that suggested that they ought to be washed before wearing, and therefore he did not do so. He subsequently suffered skin irritation, but continued to wear the underwear for the rest of the week. It is worthwhile to note that in this era, it was an ordinary custom of ordinary people to change one's underwear only once a week. The skin irritation eventually worsened and developed into a severe case of dermatitis. This was due to an excess of sulfur compounds found within the garment. The plaintiff then sued both the retailer and the manufacturer, but for the purposes of this video, we will only be looking at his claim against the manufacturer, Australian Knitting Mills. The plaintiff alleged that the mill had been negligent in failing to take reasonable care in preparation of the garments. The Supreme Court of Australia held the knitting mill liable for negligence, applying Lord Atkin's Neighbour principle in the landmark decision of Donohue and Stevenson, which was decided less than 12 months previously. It held the manufacturer owed a duty of care on the following reasons. Firstly, because it was intended that the underwear would reach the consumer in the same condition as when it left the manufacturer. Secondly, there was no reasonable possibility of testing for the presence of sulfur compounds. And finally, the Australian Knitting Mills knew, or ought to have known, that the absence of reasonable care in preparation of the garments would result in an injury to consumer. It can hence be seen that the decision of Donohue and Stevenson, along with Lord Atkin's Neighbour principle, has set an important precedent for cases that followed it.
Now, we will be looking at criticisms of the Neighbour principle after it was established in the case of Donohue and Stevenson. A question that would be raised concerning this principle would be, who exactly would be affected by negligent actions? One main problem with this principle is that it was just far too general. And although it was a good move away from just relying on privity on contract, this principle didn't sufficiently cater to every case because every case had different facts and needed to be addressed in ways that the principle didn't cover well enough. For example, the Neighbour principle is generally easier to apply to cases concerning negligent acts. But what about negligent misstatements? The case of Hedley Byrne and Heller and Partners brought the courts to consider not just proximity and foreseeability, but stated that there needed to be a proof of special relationship between the parties, which is a modification of the Neighbour principle. And this would benefit the party that experienced the loss, because even if the outcome of the negligent act was something that wasn't foreseeable, the role of the court is taken a step further to consider the rights of the plaintiff, acknowledging that they were reliant on the opinions of the defendant, who had supposed expertise on the subject, and could be both positively or negatively affected by trusting any advice given by them. Furthermore, James Edelman, who is a justice from the High Court of Australia, pointed out that the Neighbour principle places its focus on proving the fault of the defendant rather than the rights of the claimant. And while in some sense this may protect manufacturers who didn't see an accident from occurring, preventing a potential floodgates of negligence claims, the rights of the plaintiff is left hanging out to dry. In his speech addressing the inconsistency of the law of tort, where certain torts focus on the infringement of rights of the plaintiff and others on the fault of the defendant, he says, in the latter group, there are then many difficult value judgments required to determine the boundaries of such liability for fault, particularly in cases where economic loss is caused to a plaintiff, but no particular right is infringed. Hence, after Donohue and Stevenson, the courts would begin to find ways to tighten how they establish duty of care. They didn't just see that the principle needed to be more specific in addressing different types of claims, but much later, as you will see, the courts began to take into account that they didn't just need to protect manufacturers. They had to look into the rights of consumers and protecting relevant individuals as well.
Hi, I'm Audrey Ng. So in order to go further in depth about the evolution of duty of care under negligence, in the aforementioned case of Home Office against Dorset Yacht Company Limited in the year 1970s. This case was about a group of young offenders on a weekend outing who escaped from a bistro home and caused damage to a plaintiff's yacht. Basically, in this case, the courts held that the Home Office employees were liable for the damages caused by the bistro boys. This case proves that there was a duty of care expansion by applying Lord Atkin's Neighbour principle in this particular case. Not only that, the courts adopted a broader approach in Ant against Merton London Borough Council, where the defendant was held liable because he failed to comply with the building foundation laws, thus causing the foundation to be unstable. From this ants case, Lord Wilberforce created this two-stage test. In stage 1, was there any sufficient proximity between the defendant and the claimant for damage to be a foreseeable possibility of any careless act or omission? In stage 2, is there any policy consideration, or in simpler terms, should there be or not be a duty of care? The difference between these ants tests from the Donoghue and Stevenson will be that proximity is automatically established if there is a proximity of damage, and there is always a presumption of duty of care. However, ants test came under a lot of criticism. Firstly, whether or not it was just and fair to impose a duty is a more appropriate test than a mere policy consideration, as mentioned by Lord Keith in the Governors of the Peabody Donation Fund and Sir Lindsay Parkinson and Company Limited case. Secondly, the test should not be giving the court a free hand to determine what limits to set in each case. And this statement was made by Lord Oliver in Lay and Civillan Limited against Alacmont Shipping Company Limited. Thirdly, ants test has obscured the important distinction between misfeasance and non-feasance, and this statement was made by Lord Bridge in Current and Northern Ireland Co-ownership Housing Association Limited. Finally, Lord Keith had this to say about the ants test in the case of Yuen Kuan Yew against AG of Hong Kong, which was, ants test has been elevated to a higher degree of importance than its merits, and this, he felt, was probably not Lord Wilberforce's original intentions. All these judgments show that a much more cautious approach in determining the existence of a duty of care than need be the case under the two-part test. As a result, the two-part test was in fact later discarded, and the case of ants was also overruled.
Hi, I'm Kelvin. Now I will be talking about the case of Capero Industry against Dickman. The respondents own shares in the public companies whose accounts for the year ended 31st of March 1984 showed profits far short of the predicted figure, which resulted in a dramatic drop in the quoted share price. After receipt of the audited accounts for the years ended 31st of March 1984, the respondents purchased more shares in that company and later that year made a successful takeover bid for the company. Following the takeover, the respondent brought an action against the auditors of the company, alleging that the accounts of the company were inaccurate and misleading in that they showed a pre-tax profit of some £1.2 million for the year ended 31st of March 1984. When in fact, there had been a loss of over £400,000, that the auditors had been negligent in auditing the accounts, that the respondents had purchased further shares and made their takeover bid in reliance on the audited accounts, and that the auditors owed them a duty of care either as potential bidders for the company because they ought to have foreseen that the 1984 results made the company vulnerable to a takeover bid, or as an existing shareholder of the company interested in buying more shares. The court held that the three criteria for the imposition of a duty of care were foreseeability of damages, proximity of relationship, and the reasonableness or otherwise of imposing a duty. In determining whether there was a relationship of proximity between the parties, the court, guided by situation in which the existence, scope, and limits of a duty of care had previously been held to exist rather than by a single general principle, would determine whether the particular damage suffered was the kind of damage which the defendant was under a duty of care to prevent, or whether there were circumstances from which the court could pragmatically conclude that a duty of care existed. The result of this case was the three-stage test. Firstly, whether the consequences of the defendant's behavior were reasonably foreseeable. Secondly, whether there is a sufficient proximity between the parties for a duty to be imposed, and thirdly, whether it is fair, just, and reasonable in all the circumstances to impose a duty. And this test is still being used now.
Over the course of history, we haven't seen any more modifications to the neighbor principle post-Caparo. It can be noted, however, that judges are taking a more flexible approach to the principle. And this can be seen in the case of Rondo and Worsley, where the court was not prepared to impose liability on a barrister for his conduct in court. And this just comes back to the same problem that the neighbor principle had in the first place. It still struggles to sufficiently address cases where the facts are different, even if a little. Hence, instead of adding more exceptions or trying to create a shoe that just won't fit, it is best that the neighbor principle remains a conceptual foundation. Ultimately, it should be the courts that make the final decision, instead of total reliance on this principle. To conclude, over time the law has developed to accommodate negligence claims of varying nature, while seeking to protect the rights of both parties wherever appropriate. From falling back on the privity of contract, which honestly barely served any justice, to the establishment of the neighbor principle where the focus was on proximity and foreseeability, to looking at policy considerations, and finally to deciding if imposing duty of care is fair, just, and reasonable. But acknowledging that times are constantly changing and that there are no two of the exact same cases, it is recommended that the usage of the neighbor principle shouldn't be binding, but remain as a reference that judges are free to depart from, in order to cast judgment that delivers the most justice.